Let's go ahead and get started. I'm really happy to be sharing the stage with Paul Graywall. He's the Chief Legal Officer from Coinbase. You heard a lot of heartbreaking stories about crypto, but one of the things that we'll explore here, and Janet's already kind of alluded to it, we take fraud very seriously, whether that's through crypto or any other traditional form of currency or security. But one of our partners, and indeed the case that she shared, where we're able to get an Ohio investor recovery after a pig butchering scam, was by working with compliant platforms. And in that particular case, we were able to trace those funds because we were able to get information from Coinbase, actually. Just to clear that kind of a teaser as we get into this. But so Paul here, very distinguished background. He's obviously Chief Legal Officer for Coinbase, in charge of their legal compliance, global intelligence, and government relations group. Before Coinbase, he was Vice President and Deputy GC at Facebook. Also has served as a federal magistrate judge for the Northern District of California, law partner at Howery LLP, and has his degrees from MIT and a law degree from the University of Chicago, obviously. The real deal. So thank you, Paul, for joining me today.
Thank you for having me.
Sure. So he's going to share his views on the state of, I guess, crypto regulation here in the United States. And I have promised him, this for a change up, that I will answer questions he has for me as a state securities regulator. So it could get interesting. We only have 50 minutes, and so we'd ask that you hold questions until the end of the session. But before I start asking him questions, I'd like to set the stage. Ernst & Young recently issued a report in July called How Retail Investors Are Making Digital Assets Part of Their Lives. And so first thing that the report does is just acknowledge the obvious, which is this is a $1 trillion market. It's not a passing fancy. There are millions of Americans who are invested today in crypto, and there are many millions more who would like to, but are not doing it because of the lack of U.S. regulation or lack of clarity on regulation. They found that 64% of retail investors globally have already invested in digital assets. So 2/3 of investors have already done this, or digital asset related products. And 72% of those investors consider digital assets a key component of their wealth strategy. Again, this is not a passing fancy. They found that these investors prefer to invest in registered vehicles and that comprehensive financial disclosure is important to them. It's very hard when you don't have a lot of registered products to get that comprehensive financial disclosure. And we'll talk about that as we move forward. Just this week, I saw a consortium called the Global Digital Asset and Cryptocurrency Association release proposed information guidelines for certain tokens made available in the US. And their stated goal is to enhance transparency and informed decision-making in the token market. The steering committee that drafted these guidelines borrowed directly from existing disclosure forms like the Form 1A, the S1, F1, forms that some of you in the audience use to raise capital for companies here in the United States. As a regulator, I believe registration and disclosure regimes are important components of market integrity. I want our Ohio investors to make informed investment decisions, no matter which marketplace they are investing in. Let's talk about token registration and disclosure registration requirements. So where do Americans go when they want to dabble in the crypto markets? One of the most popular places they will go is to Coinbase. So Paul, I suspect we have some Coinbase users in the market, probably here in the audience, but for people who aren't familiar with Coinbase, tell us a little bit about the company. What does Coinbase do? How do users interact with it?
Well, there's a lot to address there. Let me first of all thank you, Andrea, and thank your entire team for the invitation to come back to Ohio and have a chance to flush a little trauma out of my system. 28 years ago was the last time I set foot in this building when I studied for the Ohio bar exam. So I appreciate all of you helping me process a lot of feelings. Let me explain a bit about who Coinbase is for those of you who may be less familiar. We are one of the world's largest cryptocurrency platforms. It's a place to buy and sell and trade digital assets or cryptocurrency tokens, but also to do much more. We offer a range of financial services and products that are all predicated on the blockchain. Um, Everything from staking services, for example, payments, commerce products that ultimately we think will bring not just the 52 million Americans who have already purchased digital assets in one form or another, but ultimately hundreds of millions of Americans, potentially a billion or more people around the world. Um, we are a company that was founded well over a decade ago here in the United States. We are now publicly listed and have been for several years. So every quarter, we dutifully file our materials with the SEC and report to our shareholders as every public company does. I highlight that fact because I think part of what I hope we have a chance to explore today is the benefit to investors and consumers from American founded, but more importantly, American regulated entities in this space. Yes, for purposes of recovery of scammed or defrauded assets, which I think is an important issue, but also for general oversight and confidence in the markets that have emerged in this space. I'll just add one other point, Andrea. I think you rightly highlighted that these numbers that we tend to throw out in conversations like this one can get, I think, a bit dense, but they fundamentally, I think, paint a very important picture, which is that, like it or not, Americans want this technology and these assets in their financial future. And so one of the reasons why I've come here today, I enjoy spending time with a broad, diverse audience like this one, is to talk about how do we keep these people safe? How do we promote sound practices that give people confidence in these markets? And at the same time, how do we preserve the opportunity to grow this technology here in the United States so that the jobs and benefits that flow from that don't necessarily all flow to other regions and other parts of the country that, or other parts of the world rather, that not only will enjoy economic benefits that belong to the United States, but also are outside the purview and scope and reach of U.S. law enforcement.
Thank you for that. Let's talk about ways that Coinbase is able to keep its users safe. If you look at Coinbase marketing and advertising, you guys pride yourself on being the most trusted place for people and businesses to buy, sell, and use crypto. I will tell you, in Janice's case and enforcement, we see every single crypto platform say that, right? Trust, security are important things that, for investors. And so, but for Coinbase, it's not just lip service, I would say. So what are you doing to keep your users safe?
Well, first and foremost, we operate here in the United States under U.S. supervision at both the state and federal level. And that may sound like table stakes to many of you with experience in more traditional markets, but that is an issue I think that is important to bear in mind. At the state level, we are licensed by something like, depending on how you count, 45 or 46 states which offer money transmission licenses. Our licenses extend at the federal level to licensure and registration as a money services business with our friends at the Department of Treasury and FinCEN in particular. We actually have broker-dealer licenses with the SEC, although they are not currently active for reasons I suspect we will talk about in a moment. And we are also overseen at the CFTC, where we are subject to oversight by virtue of our DCM and FCM, which also implicates the National Futures Association, or NFA. So we start with the premise that this should be a licensed, regulated business, and we've pursued all that licensure and all the attendant supervision that comes with that. Separate and apart from that, we heard earlier from Janice about the importance of KYC and AML programs. And so Coinbase has a very robust Know Your Customer and anti-money laundering program, which aims to identify and understand who is operating our platform on any given day, what transactions they're entering into. We have a very significant capital investment in a transaction monitoring system and program to review traffic on the network in the form of trades and other activities, so that we are able to, in real time or near real time, identify potentially fraudulent activity. We comply with the Bank Secrecy Act in filing suspicious activity reports where warranted, and that is a significant element of our program. And I should also say that we also proactively engage in due diligence and enhanced due diligence programs to understand who the actors are, even before they may be engaging in suspicious activity, so that we can have as clear a profile and picture of the individual operating in these markets, so that where issues arise, we can move quickly.
there's a lot of money. I'm going to use money as my term for what's changing hands on Coinbase platform. I have people in this room that think that money constitutes securities. We have some people that think it's commodity. Some say no, it's just all utility consumption. So lots of different views on that. It's complicated, but Paul, what do you think?
Well, to that set of questions, I answer yes. All of them. I think that properly understood, many transactions involving cryptocurrency tokens or digital assets fall outside the scope of the federal and state securities laws, but that leaves many others that very much implicate those laws. One of the reasons why we have been so aggressively pursuing registration and a legitimate path to registration at the federal level is that we would like to be able to offer opportunities for securities transactions on our platform, because we do believe that you can structure a securities transaction out of just about anything if you meet the requirements of Howey. I think part of the confusion that we have struggled with, to be gentle about it, is that we have seen an application of the Howey test and the definition of a federal securities transaction stretched and twisted in ways that we think are unnatural and contrary to law. And it's, there are no bad faith or fault of anyone, I suppose. I do think that Professor Adler actually this morning touched upon a very important theme that we have certainly seen in our industry, which is that we are attempting to pour a lot of old wine into new bottles. In that we have laws that were drafted in the 30s that were clearly contemplating transactions involving digital assets, transactions that involve tokens that could implicate properties of securities transactions, but also that have very important utility and currency and payment and other non-securities purposes that also need to be accounted for. And I think that's also given rise to some of the confusion that we've seen in recent memory when it comes to applying how we see digital assets. The other thing I'll just say on this broad topic is that I am ultimately an optimist. I think I have to be in this work in that legislation is now moving through the Congress. I think will enhance the stability, security, and predictability of these laws. There's an important bill that's made its way through the House, the FIT 21 Act. There are laws governing stable coins that we think will also help that are moving their way through the Congress. So I think legislation will be very important and effective ultimately when it's adopted. I'm confident we're going to enter into a period of rulemaking at some point in this space. To date, we have not. In fact, I'm the rare general counsel of a publicly listed company, not only asking to be regulated and asking for a rule, I'm suing for that purpose. And so I'm hopeful one way or the other we will see rulemaking initiated in some form that will bring some clarity. And then of course there are, and as I think was discussed this morning, court cases can take a long time and can often be unsatisfying in their scope and full application, but they are doing. And so I do think the courts are going to play an important role here in providing some clarity that we haven't yet seen.
That I'll have to do some disclaimer, which is Paul's opinions are not necessarily Andrea's opinions, and Andrea's opinions, which I will share for the remainder of the presentation, are not necessarily those of the Ohio Division of Securities
Or Paul's.
Or Paul's. We need to have these conversations and open two-way conversations, and so. Janice walked through a lot of cases where the Ohio Division of Securities has deemed crypto transactions to be securities. I stand behind those. I stand behind the Howey test and investment contract analysis, absolutely instrumental to recovery and criminal justice in every Ponzi scheme case that we real people, real dollars hanging in the balance. And so but that doesn't mean I don't think that there are ways to get there. And I think the rulemaking process or perhaps the legislative process are where these things have to be worked out. But one of the recurring themes in Coinbase's petitions, briefs,
we file a lot of papers.
You have to really, I feel for you because you really do have to fight this battle in every single way possible. On every front possible, because as we did discuss during the morning session, crypto is not new. We do have millions of people investing in it, but it's grown to $1 trillion market over a decade, and we still don't have any legislation. If you don't think the SEC should be doing it because that's, outside of their discretion, then we should have some legislation that lays out the rules for Coinbase, for me as a regulator at the state level, and for others, and we don't have that yet. So it's pretty frustrating. So, but one of the recurring things in all of the battles that you're fighting is that the securities laws are not fit for purpose. So can you give us a couple of good examples of that to help people understand why Coinbase hasn't just come in and registered, right? Because that's what we hear, right? That crypto transactions and these tokens and these offerings of securities, the law, even though it was written 100 years ago, is flexible enough to accommodate these transactions. There is an existing registration process. That's what needs to happen. Coinbase, why don't you just come in and register?
Well, we've tried. I have recounted in other settings the efforts we've undertaken to work with our counterparts at the Securities and Exchange Commission to define a pathway to registration that would allow us to do exactly that. I'll just highlight a few of the issues that have arisen in those conversations. So it's been the entire time they've been allotted talking about my.
The question has 100 questions.
Well, I'll try to cover maybe one or two. Yeah. So the challenges range on topics as wide as the nature of the disclosures that issuers should and must provide. You highlighted that there are a number of good concrete proposals already in circulation around what issuer disclosures could look like in the context of cryptocurrency or digital assets. We have included our own views on what that could look like in our petition for rulemaking. But as currently set, issuer disclosures are both, in my view, under and over inclusive. Other challenges that I think the current registration regime presents, side-by-side trading is a very important element for. Yeah, well, the easiest way to understand this is that as a registered exchange, it is not permitted under the current rules to list both commodities transactions as well as securities transactions. And given the dynamic and varied nature of digital assets, that's an important element of providing a comprehensive platform, a full suite of products and services that market participants demand. And the current rules.
Bitcoin is not part of
that would be pretty hard. That would be pretty challenging. Or Ethereum, because I think at least at this point we have consensus that at least 2 tokens are not securities, and so that's a particular issue. And each of those tokens, just to give you all a sense, or I should say, collectively account for. Please don't hold me to this, but at least half, or perhaps 60 or even 70% of markets on any given day in terms of trading volume. There are other issues with regard to registration. The nature of the blockchain itself, which is the fundamental nature of these networks that undergird many of or all of these cryptocurrency tokens, also presents challenges in terms of the nature of settlement. One of the virtues, one of the real advantages of a blockchain-based network and cryptocurrency based transactions is they can settle instantly, and they don't require clearing agents and transfer agents and T+2 or even T+1 settlement requirements that are present in more traditional markets. So what we are, I think, confronted with was a quite reasonable request that we have a registration regime in place with the oversight that attaches to it, but a scheme which does not yet accommodate the both technical and commercial realities of this market that we think are going to be very important for them, again, to continue to flourish here in the United States and develop. So that's the problem. There are solutions. I think that's the good news, Andrea. And I alluded to one of them, which is legislation that the House of Representatives passed earlier this year. It's called FIT 21. It basically provides for, without giving you a blow-by-blow account of all the different titles and sections, side-by-side trading, as I mentioned, a clear articulation, or at least a clear articulation of the respective jurisdictions of the Securities and Exchange Commission and the Commodity Futures Trading Commission. It enshrines the concept of decentralization, the evolution of these networks from something that is under the control of one or a small group of individuals, one that is truly distributed as a touch for supervisory authority by the CFTC versus the SEC. Fit 21 would also provide for the first time spot market authority for the CFTC in order to police this market or these markets, which we think is critically important. And it would also make explicit that an entirely separate area worthy of a conversation like this one, DeFi, would be addressed in separate legislation altogether. So we think that provides a useful template. There are folks who have problems with certain elements or provisions of that bill. That's why we normally have reconciliation. That's normally why we have a legislative process, but we do think that's an effective model. And then I also touched upon the fact that stable coins, which are cryptocurrency projects or tokens, which are backed fiat currency, most commonly US dollars, sitting in reserve accounts or dollar equivalents. There are, I think, important standards that need to be enshrined in legislation around reserve requirements, what instruments can back up these tokens, what disclosures need to be made to investors or purchasers prior to the transaction being consummated. That legislation, we think, could also move forward and offer further protection to investors that currently is lacking, and I don't think serves anyone's interest.
About Fit 21, I confess that I'm not an expert on the legislation. I'm not a crypto expert. There are other people in the audience who may want to spend some time and when we have time for questions to share views. But I'll ask some questions because the Ohio is a member of NASA, and NASA has weighed in on this particular legislation. And one of the concerns that I think NASA has, and I'll admit that I share, is I believe Fit 21 is relying more on the CFTC to kind of be the and so I have a resource concern, right? I mean, I think all of us, industry regulators and investment public, in order to have a market with integrity and faith in, need to make sure that there are the adequate resources there, just bread and butter resources to register these products, to oversee this market. And the CFTC is really going to grow and change dramatically in order to really, I think, have the resources necessary to undertake that responsibility. We really want to federal government in order to make this happen. When you look at the SEC, that is, really built for purpose in terms of regulating this market. So I would say that when you look at, you do not want to grow the federal government, and I don't know many people who want to grow government at either level, state or federal. The natural and the logical choice would be to shift that responsibility to the SEC.
I guess I would say a couple of things. One is, I think we would all agree, particularly David, Janice, and others have shared over the course of the day, that we have a real problem. These markets need oversight, they need enforcement, and that ultimately will and must translate to people and headcount and growth. So I think we're going to have to either accept that there will be an increase in the scope or size of some agency or another, or else we're going to see this fraud problem will get worse and worse. Now, another, I think, fair point you raise is, well, where should that sit? Who has the expertise to police it? I do think that the CFTC is an important part of this conversation, but one of the reasons why I think that the Fit 21 legislation is a reasonable approach, it's not the only approach, it's not necessarily the perfect approach, is that it recognizes a dual role on an ongoing basis of both the CFTC and the SEC. And so it's not as if we would be excluding the SEC from oversight in these markets or enforcement in these markets, nor would we be robbing its very limited and constrained budget in order to fund this. I think we would all have to reach a consensus through the legislative process that this will require additional resources. This will not be, a matter of taking, dollars out of one agency and putting it to another. The last thing I'll just say on the expertise and respective respective authority of the CFTC versus the SEC. Look, I do think that these markets and these technologies are fundamentally different from the instruments that have been regulated historically by the SEC. Part of what makes digital assets or cryptocurrencies so challenging is that many of them not only have characteristics because they're used for governance, consumption, utility that distinguish them from pure assets that are used as instruments for capital formation and capital raises that ought to be treated as security. But that their individual characteristics or the characteristics of individual tokens themselves can change over time. And so I do think we just need to adopt a more flexible approach. But one way or the other, we got to get there. We got to do something.
I'm with you on that front, right?
The status quo isn't.
No, I'm with you there. I think we definitely need to do something. I do think you have to have a coordinated approach that incorporates both the CFTC and the SEC for all the reasons that you just mentioned. NASA has advocated for joint rulemaking between the CFTC, provide better guidance and try to move that ball forward. I think that makes a lot of sense because again, we're 10 years into this. And that registration regime does not exist. Now, yes, the existing securities regime exists, the existing commodity regime exists, but there are challenges, that side-by-side issue being one of them, that has to be resolved in order to really make the workable regime.
I think that's right. Now, at the beginning of our conversation, Andrew, you did invite me to ask. Can we do that now? You brought up NASA a few times, and I think it would be helpful for all of us, myself certainly included, for you to share a bit about how you work through NASA to coordinate with your colleagues across the country.
Sure. Yeah, so NASA it's not the space astronauts, don't get excited. It is the North American Securities Administrators Association, every state securities division in the country, as well as the provinces in Canada. And our friends in Mexico are members of that organization, and we do work very closely. I currently serve on the board of directors for that organization. Janice is very active in the enforcement section. All of our managers have some kind of active role in that organization. So we talk about these issues, we talk about policy, we work together. We also have another administrator from the state of Missouri sitting there in back. Jacoby is joining us today. And so the reason I know Doug is because of NASA. We work together on NASA. Does not mean we always agree on issues. And so crypto is definitely one of those, divisive issues. There are some states, I think, that are crypto friendly. There are states that are crypto skeptics. There are states that prosecute crypto fraud all the time. We are one of those states. So certainly we work together. We try to come, together where we can on policy. It doesn't always happen, but the communication lines are there. There's someone in every securities division in every state in the country that I know personally that I can pick up the phone and call, which is a gift.
It is a gift, and it's also a gift. One word that you didn't mention describing NASA was partisan. These issues don't have to be blue and red or Democrat or Republican. One of the things I think that very much in line with the dynamic you described to me about how NASA works is that I mentioned the Fit 21 bill now several times. That was passed in the House with the support of 71 Democrats and almost all Republicans. And so it proves there can be a bipartisan consensus on these issues in a way that I think stands out in our current environment. I'll put it that way.
Well, let's get back to Fit 21. And so I already mentioned I'm worried about CFTC being given authority that it may not have the resources to handle. I think that has market implications. We don't want crypto winter. You don't want crypto winter 2025. That market, is $1 trillion market one day, will not be $1 trillion market the next day, and so things can move very quickly. So if you don't have a regulator that can stay on top of that, the market will suffer, right? The other thing that is Howie, an investment contract analysis. Part of Fit 21 is trying to, I would say, trying to discard investment contract analysis in the Howie test in order to get to the finish line in crypto without fully assessing what the consequences of throwing out that very important test that's been around for a century for a reason. And so that's another major concern from the state regulatory crowd, which is, I'm with you that we need to get a registration regime in place. We want disclosure. We want AML. We want, all of the things that we're seeing the industry do on its own accord, perhaps, or maybe doing in other regimes. But we don't have to get rid of Howie investment contract analysis to get there. So I'm very concerned, especially in Congress, their desire to get to the finish line, to be the one whose name is on the bill that finally resolves this problem, that in their desperation or in their haste to get that done, they're throwing out something that's really valuable for securities regulation. And for us, that would be devastating. All of the criminal cases that Janice just went through, we relied on investment contract analysis and everything. We did 40 orders, formal orders so far this year. 60% of them involved a crypto asset or a digital asset. A good chunk of them we were able to investigate and issue an order because we had assistance from funding. We would not have been able to get recovery in those cases. And so I do think a lot of people want to put all crypto into one bucket, right? It's very tempting to put everybody in one bucket, but there's differences here. And once that money is offshore, it is gone. And so one of the things that, as a state regulator, I struggle with, and I think probably NASA and other states that have a lot of crypto fraud cases struggle with, is because the absence of a registration regime is inviting additional fraud, right? I would like to be able to tell Ohio investors, as part of the pig butchering video, that you need to avoid these platforms because they're not registered and they're offshore. But I can't even say that because none of them are registered, right? I can say, at least if it's in the US, maybe you have at least a better shot at getting your money frozen and getting some kind of recovery. But it's a tricky thing to even say that, because am I vouching and betting for some unregulated entity when I do that? So it is really all of that uncertainty is being exploited by the bad actors in the Asian, workshops. It's not all in Asia; it's all across the world, because they know there's no registration process. They can lurk and hide and exploit that lack of regulation or that lack of registration, at least, to continue to defraud people. I think we heard Aaron West say $4 billion last year alone.
The numbers are huge, and the pain inflicted on real people is massive, and it doesn't have to be that way. On your Howie point,
Yes.
can I just perhaps give you some comfort? I think actually. I actually think it is in Fit 21. I would argue it is Howie plus. I think there's an important clarification that needs to be addressed, which is what happens as these projects decentralize over time. Here's my fundamental problem, not with the Howie test, but how it's been applied. There is no way to reconcile current application of the Howie test to digital assets, which are charged in all these enforcement cases, with the two assets that have been not charged.
So what I would say to that is, I think there needs to be crypto-specific regulation and guidance, right? The SEC has asset-backed security guidance, right? Yes. So that didn't fit neatly into the Howie construct either, right? And so there are analogs, there are regulatory frameworks that the SEC could use, or other folks could use, in order to provide crypto-specific, crypto-accommodating regulation that gets these platforms registered, so that I can say, look, I don't vouch for anyone whether they're registered or not, because some of the people in Janice's cases are licensee. However, I will have great comfort knowing that there is a regulator with the resources necessary and register those entities who are being reviewed independently to provide, again, that comfort that I would like. But I don't have that now, and I can't do that until these issues are resolved. What I would say is, take your sights off of Howie, take your sights off of the investment contract analysis test, because you're going to get a lot of things that you do not want to. And really focus on, let's get that crypto-specific guidance and regulation in place without throwing the baby out with the bathwater.
I'll offer you this trade, Andrea. We could keep Howie largely as is, But ABS, asset-backed securities, offer, I think, an excellent model for how you can draft specific guidance that, as you point out, doesn't leave open questions about decades of precedent in ways that shouldn't have to be impacted by those. Well, I think recognizing, that these are new technologies, these are new markets.
How, did you talk with the commission about that approach, and what was their response if you did?
I have spoken at length with the commission about this. They declined to pursue that option.
Very good. Let's see, what else?
I still think, by the way, you and I could be locked in a room for 36 hours and hash out these differences.
Yes.
Well, what I find frustrating, again, it's been over a decade, so every year we do this conference, every year we talk about crypto, probably for the last 10 years. And every year, I used to, I don't do it anymore, I'm like, by next year, there's going to be legislation, or next year, there's going to be crypto-specific rulemaking at the federal level. Because I can't do it, I am helpless as a state securities regulator. We are really helpless. This requires a federal solution. We want to preserve our anti-fraud authority, right? Because I'm sorry, neither the SEC nor the CFTC is going to pick up the phone and take the $10,000 victim. We take that victim. We showed you up there that we not only take those cases, but we get recovery when and where we can. So it takes that whole village of financial regulators in order to really make a market work. And so from my perspective, I need federal regime in place, and I need to have anti-fraud authority so that when my Ohioans lose money in this market, as they already are and will continue to do undoubtedly, that I have the ability to, one, find the bad actor, stop the fraud if I can, and if not, at least provide some recovery to these victims.
It's all very important.
I think we have, did you have any other questions for me, Paul?
I'm gonna get all kinds of questions, but you're the boss, so.
I have some other questions here, but I know I suspect you are one of the few speakers. I suspect some people in the audience might want to have some questions for you. So I will pause here to see if folks have questions. Yes, of course you can.
So I had heard that Coinbase rejects something like 90% of the coins that seek to list on their platform.
Closer to 95, actually.
Can you talk about what you look for and why those are rejected?
Yeah, well, in the absence of guidance, and specific application of Howie, we have attempted to do our level best to develop that guidance for ourselves. And so we go through the factors that, Andrea has rightly pointed out, have served these markets generally for 80 or 90 years. And in many cases, most cases, 90 plus 95% of the time, find either that the proposed asset listing fails for one or more Howie reasons, or we also conduct security with a small s. This is as in cybersecurity, the projects, and we also conduct a complete compliance review and regime as well, to assure that we have the ability to analyze and investigate issues as they may arise if we were to list. And most of these projects, most of the time, can't pass even those tests, even before we get to Howie.
Just a very quick question. Do you use the technology that they use for the enforcement, for example, to mitigate the risk, and as part of your compliance, have you been using this new technology that can locate the wallets?
Yes.
And what do you do with that? I know they do. I'm curious on whether you have that.
The answer is yes. So even the very tool that Janice mentioned, Chainalysis, is something that we use as part of our cryptocurrency investigations. Coinbase has also developed other internal tools that we use for tracking and tracing as well.
Why do we want it?
What good is it for? Is that your question?
Sure, how did we get in this position?
Yeah,
There.
yeah.
Well, did anybody question along the way, why are we allowing this to happen?
Yeah.
I mean,
Well-
not how we're gonna regulate it, but what is this and why are we even letting it
Right.
continue?
Well, for most people in this room, the current financial system, myself included, works great, right? We have access to investment and payment solutions in a wide variety of different products and services. if you talk to people who are most active and interested in these markets, typically under the age of 45, they're looking at the current financial system and saying, we want an alternative, or we want a parallel or additional set of choices to make, and where we invest and how we develop our financial future. The fact of the matter is, the original white paper that gave rise to Bitcoin, the original cryptocurrency, talked about shortcomings and flaws in our financial system generally, but in particular payments. And one of the most important use cases for cryptocurrencies that go beyond just speculation is in improving and enhancing payment systems that in ways that eliminate the intermediaries that exist at many different steps along the way between a transaction from one point to another. So the fundamental opportunity that blockchain networks provide for financial services is in reducing or eliminating the intermediaries which add to the transaction costs of payment systems, both peer-to-peer among retail people like you and me, or among institutions who are managing treasury. So that's one use case, and the original use case. Why else should we care? Well, these distributed networks, which don't require a central actor to validate the authenticity and legitimacy of transactions, can also provide for other solutions in areas such as digital health records, in terms of content creators owning their own individual online identities and being able to take those identities and move them to different platforms. So these are technologies. They are supported by tokens, which tend to attract a lot of the attention. But at the end of the day, this is just another layer on the internet that will allow for additional products and solutions as people develop them. That's why people are excited about this. And even if you don't buy any of that, and that's of course reasonable, 50 plus a million Americans have said they do. So what are we going to do about that? Even if we're
Yeah, to me, I think, and Nasty's like, take a tech neutral approach. I don't care if you believe in it, you hate it, you whatever. There are 50 million. I don't know if it's 50 million, but whatever. There are millions of Americans who do believe in it, who are using it, even though, 10 years down the road, we don't have a registration regime in place in the United States to really cover it. There's a million reasons why they may not trust the dollar. They may not trust the government. It's their alternative to gold. Whatever the case may be, there are millions of people who are interested in it, who want to invest in it. And knowing that as a regulator and seeing how much money is being lost in that market, I want to try to put some structure around it and try to make it as safe as you can. And it's a daunting task, but we're never going to be able to achieve it if we're not working together with legitimate actors and people who are, again, trying to make this as safe as you can. Come on, Jake.
I do look like
Is it or is it first call?
Question, we're talking about all these financial transactions, whether or not they're securities or commodities, but what's the tax ramification?
Yeah. Well, the tax ramifications are a good chunk of these transactions should be subject to tax reporting and ultimately taxpayer compliance and collection. The IRS has promulgated a number of rules for reporting that are principally directed at centralized exchanges like ours, such that we can and would issue 1099s and other standard tax reporting to the IRS and to the individual account holders. But again, because of the nature of the technology, in many instances, these tokens are not being used for speculation or being acquired for purposes of appreciation. They're either payment tokens.
A lot of them are.
Let's pay taxes on them, which is why I support the ruling. But there are many cases that are not. And the fact of the matter is, if the tax rules can flex to that and adapt to accommodate that, I think they can work reasonably well. We know how to do tax reporting in these markets generally, so I don't see any reason to despair that we wouldn't be able to accommodate whatever unique issues are presented when it comes to digital assets. But
Currently, there's no taxes, right?
oh no, there are. You better be paying your taxes. I do.
Platforms are reporting that, so that taxation is happening. the non-compliant, are not. And so, you know.
And this gets at a very important point as well that we've touched upon. The regimes and rules for taxes, for securities treatments, for commodities treatment, they need to be generally applied, or else you create distortions in the markets that drive out people who are investing in compliance programs, investigations, and the rest, and essentially push these millions of
To the
people
unregulated.
to the unregulated spaces. I don't think that serves anyone's interest.
Other questions?
Yeah, you mentioned stablecoins, which is an area of particular interest of mine, and I think it's pretty clear the stablecoin plays an important role in transaction facilitation and in temporary holding capacity, and also seems to, according to some academic research, to have been used as a way to potentially manipulate some of the cryptocurrencies out there. And there's also apparent to me a lack of transparency that persists, that it has yet to submit to a full audit. We still don't have comfort from a consumer perspective that the money that they purports to have is in fact there. From your perspective, given that you use USDT on your platform significantly, it's in your number 3 or number 4 on your listing. Do you have concerns about that? What are you doing to get comfort that you're not inadvertently helping the other side of the fence, if I can put it that way? Any comment?
I have many concerns. It's one of the reasons why I want legislation. I think reserves should be audited. I think there should be full disclosure. I think the audits should be real. And we should be talking about audits from all the firms that we know and love, not bit players that have only appeared to service one client or one particular company. I think stable coins are critically important, not only because they do often collateralize much of the trading activity, but we're now seeing tremendous uptake and adoption for purposes of corporate treasury management. The fact of the matter is that a dollar-backed stablecoin in particular is a much more efficient way to manage flows across jurisdictions among entities than your standard cash management. The last thing I'll just say is, and this where I'll put on my American hat and my American flag, maybe, there is a tremendous opportunity with dollar-backed stablecoins, which comprise 95% of the market, depending on how you measure it, for the U.S. to continue to assert its preeminent role, its dominant role in the global financial system into parts of the global economy that are otherwise untouched and out of the reach of the U.S. dollar and therefore the U.S. government, right? To put it another way, if you're sitting in Argentina or in Turkey or in Nigeria, in places where inflation is 20, 30, 100% per annum, a dollar-backed stablecoin is a very attractive way to preserve some of your purchasing power from your labor. That's good for America. That's good for the US dollar. In order to maintain and preserve that, though, we need rules so that people can have confidence in these instruments.
All right, I think that's all we have time for, unless David, do you want to give anyone else one more go real quick?
Someone has a very quick question. We are at 2:35. Nope.
I had one just, I don't negate the need for regulation and the benefit that can come from the country, but why the securities regime? I mean, the defense you gave, convinced me that it's either a commodity or it's a currency. I mean, there's huge markets in the world where financial transactions happen, where people can get scammed. And we don't expect our securities laws to bend or to change to meet them, like gambling, for instance, or anything else like that. I just don't understand this, especially given the fact that our entire morning talked about regulatory creep beyond, what Congress meant when they passed statutes.
I think it's an excellent point to end the discussion, Andrea.
Right, no, I think, you obviously feel very strongly about that. I feel like the structure that has the capacity to handle that. There are so many actors involved, so many retail investors involved. The banking structure and the CFTC do not have the surveillance or enforcement resources, in my opinion, Andrew's opinion, to adequately and effectively oversee that market. And the only agency at the federal level, I believe, that does is the. All right.